Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. Um, in this particular episode, this is the next in the series of the Trump deportation series. Um, and, if you look at all the ones I've done, it's essentially from the moment, for example, that you would be put in detention or served with the papers to begin the removal proceedings, to pleading to the NTA or the notice to appear, to going forward and having a contested hearing, to declaring what your forms of relief will be, to preparing, having the filing of the petitions, to then going to trial and presenting the evidence. So here we are at essentially the end of the immigration court proceedings, and the judge is about to make a decision on your case, whatever it is. If you applied for cancellation of removal, if you applied for asylum, withholding, registry, if you applied for waivers, whatever it happens to be, um, if you made arguments that the crime you committed, for example, was not an aggravated felon for various reasons, and you're not inadmissible, or you should, qualify for the petty theft exception, or you qualify for derivative citizenship. We could go on and on, but let's just say it's coming to the end. You've done the trial, you've done the evidence, judge has asked you the questions, and now the judge is going to make a decision. So, the reason for this particular video is not so much if the judge agrees, because if the judge agrees and grants your petition, which that's a possibility, then that means you're in. That means you either get to keep your green card, it means you're going to be able to get the green card, or it means that you qualify to stay here in the US and you won't be deported. So various items can occur from being approved by the judge. Now, um, the judge can also deny the uh, the petitions for various reasons, and the judge will go on record and will list all the reasons why the case is denied. And obviously, your attorney needs to sit there throughout that and take notes and so forth, so that when the judge makes the decision, there will be, and there always is, appealable issues, which you have a right to appeal. So whether you win or you lose, it may go up on appeal. So the way it works is once you are done with the immigration court, let's say you win. Okay, immigration, they have 30 days in which to appeal the decision to the Board of Immigration Appeals. Now, let's say you lose. You have 30 days in which to appeal the case to the Board of Immigration Appeals. This is essentially an organization in Virginia that 100% all over the nation, including Puerto Rico, all the immigration courts, once a decision's made, the respondent, which would be you, the person who's in detention, will have a right to appeal. That's part of the both the administrative law, and it's also part of our due process, which allows somebody who gets a decision which they don't agree with to go up and appeal. So the appealing, of course, has to be done within 30 days. Now, if you appeal 30 days and 5 minutes, minus some exceptions, it's garbage. It won't happen. They can take as long as they want to make a decision on the appeal, but you have an absolute duty to make sure that the appeal to the Board of Immigration Appeals, or the BIA, is sent in a timely manner, and isn't sent in such a manner that is going to be summarily dismissed. Unfortunately, when people think that they can appeal themselves, they fill out the paperwork, they make what they think are good arguments, they send it in, and sure enough, the majority of the time, the BIA summarily denies it within 30 days, basically saying there's no issues of appealability, there's no realistic chance that anything will go forward. They deny it, and ultimately that would become a final order of deportation. So if we're talking in the medical field, for example, and you break your arm or you break your leg, you don't decide to go to Rite Aid and buy yourself the plaster of Paris and some tape and decide to fix it yourself. Okay, you wouldn't even think of doing that. So I'm just a little confused sometimes why people think that they can go and appeal themselves just because they feel that they have strong arguments and the judge didn't understand what they were saying. You have to realize that the appeal itself is the majority of it, the vast majority of it, will be legal argument, citing cases and citing statutes and citing essentially parts of the transcript that show why the judge was incorrect in ruling the way the judge did. Your personal feelings as to the fact the judge might be wrong doesn't really play into the legal argument, and in fact many times and most times is irrelevant and just emotionally based to try to you know get what you want across. But obviously what you want to do is you want to win, and in order to win you need to get an attorney who knows what they're doing. Okay, so given that it goes up on appeal, most of the time what happens is the notice of appeal is filed first, and it lists the various issues as to why the person must or must not win. I mean, listing all the general issues. And then what will happen, assuming it's not summarily dismissed, is the person will then be able to have the opportunity to write an opening brief. So initially, the notice of appeal is sent. The immigration court will then send the transcripts and everything, the whole file, up to the BIA. Then you'll get notification from the BIA that basically it was not summarily dismissed, and you'll get a time to do the opening brief. Immigration will then get an opportunity to do an opposing brief. You then get to file a reply brief once you read what the opposition is, and then you can select whether you want oral argument or not at the BIA. Okay, and so it's a whole procedure goes forward, and of course the hope is that once it gets to the BIA and you do the brief and the appeal, that it will be granted. So there's different things that could happen once it gets up to the appeal. First of all, there's an automatic stay of deportation once it gets to the BIA. So if you're afraid that, the moment you might lose at the immigration court, they're going to kick you out of the country, that is not the case. You get an automatic stay of deportation during the appeal. Now, once the decision is made on the appeal, it could be, just flat out granting it, which is great. It could be flat out dismissing it, which means they're denying everything, or they can remand it back to the immigration court in order for them to decide on what to do or what not to do. So the uh, the BIA can go several different ways depending. And just so you know, some people will think, okay, well, if the BIA denies my case, that's it, it's over, I'm out of here. But still, yet that's not the case. Let's just say that the BIA has denied the case. Um, it can go up to the circuit courts of appeal for what's called a petition for review, and that is going to be the particular area of my next Trump deportation series. So you will know that in actuality, appeals can go quite high, and sometimes you have to fight a few battles before you win the war. So hopefully this lets you know that even though you might have lost in immigration court, the battle is by no means over. It actually has a long way to go, and sometimes it's the only way that you can actually get the relief that is being sought. So if you like the video, click like, subscribe, and you can go ahead again and leave comments. Again, I have lots of good comments. I have lots of comments against. And again, the ones that are against are fine. Assuming that you don't cuss every other word and don't try to insult everybody under the sun. I don't mind comments either way. So more on the coming weeks. Thank you. Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to finish off the initial Trump deportation series. Not to say that there won't be a lot of other videos on Trump immigration policies, which I'm quite certain that, in a week from now, I'll probably have a whole plethora of new videos to come out on it. But as you know, there is a humongous variety and availability of different immigration topics, and we can't let everything fall to the wayside in anticipation of what Trump will or won't do. Because there is the whole Immigration Nationality Act and tons of statutes and cases on other types of visas and so forth. And so I encourage you, if you still want to come to the U.S., there's a ton of different kinds of visas, and I can certainly help you with that. But for the last, in this initial Trump series, we have gone through the initial stages of, when the immigration would get you to, what happens in detention, to fighting the case, to getting the immigration judge decision, to appealing at the Board of Immigration Appeals. And we've done some other stuff, but that's the basic synopsis. Now, the next thing you might be asking is, what happens if you lose at the Board of Immigration Appeals? Is it all lost? And the answer is no. From there, you can actually bring your case to the Circuit Court of Appeals through what's called a petition for review. And this is the first time that you will actually be able to fight your case in front of federally appointed judges in the judiciary. Up until this point, 100% of it has been through administrative process and administrative proceedings through administrative judges, never the actual judiciary. So sometimes I actually prefer going up to the Circuit Court of Appeal, because a lot of times, in different cases, you just get rubber stamped decisions, but you can't get a real judicial decision until it gets up to the circuit court. So, I always say sometimes you have to fight a few battles to win the war. Well, before you get up to the Circuit Court of Appeals, certainly you have already fought a few battles. However, understand that these judges, you'll be in front of a 3-person panel, and these justices listen to all federal law type cases, whether it's criminal or tax or patent, or civil, all different kinds. And immigration, of course, is one of them. So you get a new view, and you get a new ability to have your case heard, and you get to argue various items that they actually do have essentially the authorization to either change and or reverse and so forth. And so once it gets to the Circuit Court of Appeals, there is not an automatic stay of deportation like there is with the Board of Immigration Appeals. So you have to file the stay to to do that, and also request in case for extended voluntary departure if that's what you were given at the underlying hearing. And then what happens is the briefs go back and forward for some time, and ultimately, if they want, they can request oral argument, at which point, if oral argument goes forward, they then listen to the arguments, and then several months later, you will get a decision on your case. Now, there's basically three different decisions that can come from the Circuit Court of Appeals. And just so you understand where these courts are in relation to the whole system, you have the very, very top, which is the U.S. Supreme Court. And then below that, you have approximately 12 circuit courts of appeal covering all of the United States and then the Washington, D.C. district. So essentially, they're very high courts. They are just below the U.S. Supreme Court. And so they certainly have a lot of power. They have a lot of decision making, and every one of them was appointed by a president, depending which president happened to appoint them at the time. And generally, you get three who will hear your case. And so they can either flat out deny it and dismiss it, they can flat out grant it and reverse, or they can send it back down to the BIA with instructions of what to do or not to do, depending on the nature of your case. Now, once it's done with the petition for review, then you have other options as well. It's not over until it's over. You can do a petition for rehearing en banc, and what that means is that you disagreed with the three-judge panel, and you want all of the justices essentially on that panel to be able to listen to the case. And so, if that happens, then you end up, or your attorney ends up with a whole line of justices who will listen to the case. And then, of course, there's the writ of certiorari, and that goes up to the U.S. Supreme Court, which, that of course is very time consuming, and they do not pick very many of them. But, that, as far as judicially speaking, would be the end of the line. And as you can see, it does take years to get to that point. And even though it does take years, we're always on the lookout, because maybe it might be at the Circuit Court of Appeal, but then maybe some new memorandum will come out that will give you some other form of relief, which we can pursue on that particular ground. So, the bottom line with, my Trump deportation series is there's about, I don't know, I think I did about 7 or 8 videos in this series, and it primarily goes to show you that there's a whole lot of fight that can be put into an immigration case. And I just briefly spoke about them. I mean, if I wanted to go in detail, I'd be doing 300 videos, from beginning to end of the deportation process. But I just gave you a little flavor so you don't lose hope, that you think that the moment Trump might become president, that all hope is lost and you're going to be, forcibly removed back to your home country. It doesn't work like that. And there are lots and lots of arguments and fight that can be done. And it takes time, lots of time. So if you like the video, click like, subscribe, and also feel free to give my office a call. I do give one free consultation, let you know what can be done and so forth. More on the coming videos.